Welcome to Simply by Deal HQ. On this podcast, we engage thought leaders on topical issues around law and business in the most simplistic manner.
My name is Precious Osi, and I am an associate at Deal HQ Partners. I will be your host for this exciting event. On behalf of Deal HQ Partners, I am honored to welcome you to today's intellectual property webinar titled Ownership of Intellectual Property Rights to AI-Generated Creative Output. Who holds the rights to machine-made works? We thank you for registering and taking the time to attend this webinar. We hope that your questions are answered and that knowledge gaps are closed, at least to a reasonable extent. Okay, so Deal HQ Partners is a Pan-African transactionary advisory firm dedicated to enabling businesses operate efficiently within Africa's dynamic market. We provide stellar business solutions which help businesses navigate the unique challenges and opportunities in the African business landscape, while enabling them to operate efficiently within their market sphere. So here at Deal HQ Partners, we understand that as technology continues to revolutionize creative and productive processes, we are now faced with complex questions about intellectual property rights. Who owns AI-generated works? Do machines have a legal personality? How will IP laws evolve to address these innovations? As a matter of fact, our questions are numerous. So today, we'll explore these critical issues with our esteemed panel of expert speakers in intellectual property law, AI research, and other related fields. Our objectives for this webinar are threefold. One, to examine the legal and ethical implication of AI-generated content, to clarify IP rights and responsibilities in AI-generated works, and three, to identify potential crossroads and future directions for IP laws. By the end of this webinar, the audience will be able to gain deeper understanding of the legal and ethical considerations surrounding AI-generated inventions. They will be able to understand possibilities of AI having legal personalities. They will be able to get some clarity on ownership rights and responsibilities in AI-generated invention, gain insights into the future of intellectual property laws in the context of AI-generated inventions, and get practical guidance on navigating ownership rights in AI inventions. So to make this an interactive session and to make this engaging as well, this webinar will take the format of a panel discussion. Our expert speakers will share their valuable perspectives, and we will have a dedicated question and answer session to address your questions. Please feel free to submit your questions using the chat box. And we also encourage you to take the poll that is on your screen. It's going to come up any moment from now. You should just look for poll somewhere on your screen and you would see that. So please take the questions. All right, so to kickstart this event, I would like to introduce our esteemed speakers. So here today we have Mr. David Brown. He is the managing partner of D. Brown Consulting, and he is the CEO of D. Brown Analytics Solutions, LLC, Dubai, United Arab Emirates. He is a results-driven consultant and a trainer with expertise in financial modeling, Excel, and Microsoft Copilot. He is a Microsoft MVP, an ATD Master Trainer, and international consultant to the World Bank. Mr. David, you are welcome. Secondly, on our list of speakers, we have Dr. Ifeoluwa Olubiyi. She's an associate professor of the College of Law, Afe Babalola University. She is a seasoned lawyer, a law teacher, and researcher with expertise in intellectual property rights. She's passionate about driving societal and economic development through IP, She has authored publications locally and internationally and has trained students, policymakers, and stakeholders. With a strong academic and research background, she founded AdlerDab, focusing on technical writing, proofreading, copywriting, and editing. Dr. Ifeoluwa, you are welcome. Okay, I think the polls are now on your screen. Please take your time to answer the questions. You don't have to think too much about it. Just say what you think applies. All right. So the third speaker on our list for today is Mrs. Emily Kearney. She's the partner and founder of the Kearney Firm, California. She's the principal attorney at the Kearney Firm, APC. She offers experts outside general counsel services to businesses of all sizes. She provides tailored solutions in contract drafting, business consulting, IP protection, and compliance, with a focus on building long-term relationships and driving client success. Miss Emily, you are welcome. And lastly, on our list, we have Mr. Izuchukwu Ubadema. He's a partner at Deal HQ Partners. He's operating out of the Abuja branch. With 14 years of experience, he leads the capital market, corporate and regulatory practices, and technovation practice areas of the firm. He is a SEC licensed lawyer, consultant, and also an NBA SBL member. Mr. Izu is recognized as an IFLR Rising Star Partner. Mr. Izu, thank you for coming today. So once again, I say thank you to all the attendees. Thank you for registering and taking out the time to be here. And thank you also to our speakers for making out the time for us today. So I indulge you to make this session an interactive one and an enriching one by sending in your questions and taking the poll questions that you see on your screen. All right, so without further ado, let's dive right into the fascinating world of artificial intelligence and explore the intricacies of intellectual property rights. So today, my first question, just to lay a background, just to make sure that we are all on the same page, would be to Miss Emily. Please, can you kindly give us a general insight into what artificial intelligence is and the critical points of convergence with intellectual property rights?
Sure. Thank you so much for having me. So I think most of us are familiar with, what artificial intelligence is. And, obviously there's, ChatGPT and all these other various platforms that are creating different tools for us to use to streamline our work or personal lives, that sort of thing. And where it really becomes a concern is the way that AI works is that it doesn't actually ever think of something creative on its own, right? So it uses what exists already on the internet, or not just on the internet, depending on what the developers of the AI have placed into ChatGPT or whatever platform it is, and just generates output based on that. And since intellectual property is all about creation and the origin of intellectual property, then that's why it can pose a concern, because whoever is using ChatGPT or some other AI platform isn't going to be aware of what works or prior works were used or partially used in their product. And so that's where the complexity can arise, right? So there's various things that are put into ChatGPT that might be infringing on copyright that most of the users of AI or some other type of similar platform aren't going to be familiar with. There's also various other issues too, with data privacy. If some individuals have placed sensitive information into the AI platform, then that can also lead to data privacy issues. So there's just a very broad range of legal issues that can arise from using AI. And we'll get into this later, so I'm trying not to get into the other questions because I know we're going to get into more details of everything else. But at a higher level, it asks the question of whenever you use AI, well, who is the owner, right? And intellectual property requires human ownership. And if you're using AI, obviously, artificial intelligence is not human, but it's made in collaboration with humans. And so as this discussion develops, we will, obviously get into more details of how do those intertwine with each other, how do those relate to each other, and then also just taking a step back to realize that AI is pretty new, and we haven't fully, completely, and legally developed how this is all going to play out in the world of IP.
Okay, thank you so much, Miss Emily, for that. Okay, so now we understand that there is intellectual property, and it meets with AI in the point that some of the data that the AI is fed could be people's intellectual property, right? And then it could also breach the data privacy and all of that. All right, so with that understanding, I would like to ask Mrs. Ifeoluwa the next question. So when AI generates derivative works, at what point might these be considered an original work which does not infringe the rights of the original creator and vice versa?
Thank you, Precious. Can you hear me well?
Yes, I can.
All right. So, the concept of originality, is tied a lot to the work emanating from the copyright owner, or the author in this case, and not copying. So the question of originality of AI works will depend on sometimes what is called transformative use of the work. So how much of the creativity or creativity, yes, basically is coming from the artificial intelligence itself, to the extent that you can say that this is not copying the original work, or it is not just a mere replication of the original work, to say that, oh, this is the originality of the AI. So that question is there of how much transformation the AI has actually done to the original work, to the extent that we can say, because this is a derivative work that is original. Remember that even though generally in copyright or IP laws allow derivative works, they must also fulfill the requirements of being original. And originality here means that probably the work emanates from that person, and the person did not copy. The person has transformed, this initial work to a totally different, have put in some of their personality or some of their own contribution to that work. So the question of AI coming up with a derivative work to the extent of being said to be original, of course, it's going to be a question of fact, and it's going to be that the AI did not just simply, copy. And we also have to look at how much of human input is happening in the whole creative process. So if there's a whole lot of human input in it, the AI will simply be assisting and not be said to have created, an original work. Although that question, it also raises the question of whether we can give AI works, copyright ownership or intellectual property rights generally, because not being human beings, most of the existing IP laws attribute or consider just having human authors or inventors or creators. So the concept of an AI being an author or a creator, in this case, is also very skeptical. So I would just say that the law is developing, in a lot of jurisdictions and all over the world. So it's still a question of fact. The law has still not caught up with recognizing in many countries, AI as an author. So we still have to look at how much human input is there, how much transformation has the AI done to this work. Did it just simply copy an existing work? So I think these are things we need to consider when it comes to AI generated or derivative works. Thank you.
Okay, so with what you've said, it means that we can draw a conclusion that if it's a direct copy of the AI work, then it can't be said to be original. The human must have done something to modify and improve on what it was that the AI generated.
Yes, that's originality too. Yes.
Okay, all right. Okay, so I'll be moving on to my next question to Mr. Izuchukwu. So now that we've seen that machines now play a very vital role in most innovative processes, we see that even the innovation going on in scientific rooms, they're using technology and all of that, even down to music, poems, people that do drawings, arts, and the rest of that. Everybody finds one way or the other to incorporate an AI or a machine help. So with all of this, with machine being so involved in innovative processes, and we all know that the current IP laws will continue to come under deep scrutiny, especially with respect to the ownership and protection of AI generated invention. And the given that the current eligibility criteria for patent protection is based on novelty, utility of subject matter, which suggests that the focus is on the invention itself rather than who invented it, right? So we now want to understand why is the ownership important? Why is it important to know who created it since focus is on the invention rather than the inventor? Mr. Izu.
Thank you so much, Precious. It is my pleasure to be in this panel. In terms of the criteria for protection of inventive works and that of invention and that of inventorship, even though you've listed some criteria that are quite obvious, but then one will have to look at the historical reasons why there has to be protection to inventions or generally any IP, any intellectual property rights, the historical reasons for their protection. And these will be found in the various statutes and, of course, the conventions that international conventions and treaties that also go with these statutory laws for various various states, nationalities rather. So the criteria is not only summarized with regards to the three that you have made mention. The intention of the various draftsmen of the various intellectual property laws has to, there is an underlying intention that there must be a human inventor. And the reason for this is not really far-fetched. One of the reasons is issues of accountability, the infringement of that particular right that is being protected, and the possibility of what is even protected infringing on other rights. Who takes responsibility? There are two ways. It has to be a human. And historically, one of the vital reasons why there is need to protect intellectual property rights is for the purposes of incentivizing whoever the inventor is. So if there is no known inventor, then there is really nobody to protect. There is really no right to protect, as it were. So there must be an inventor before you can even say there is a true invention. Even though in UK, for example, in the UK Patent Act, there is a provision that has protected, that has made reference to computer-generated programs that have no known protector and no known inventor. In such cases, whoever that arranges the data and have it published gets to be protected. So at the end of the day, there is someone that must be protected so that when there is need for accountability, there is someone that will be accountable for the infringement of any rights. And once there is any economical benefits, there is someone that also have to take that benefit or otherwise. And if the right that has even been protected, whether or not it is invented by human or by AI, if there is an infringement on that protection, there is still someone that will have to lay claims on that. It won't just be an artificial person. And like I said in my introductory remarks, the idea of protection of these rights are statutory. And all over the country, all over every jurisdiction, you don't find the statutes protecting non-natural rights or non-legal entities. It has to be a natural person or a legal entity known to the law. So as it is in most jurisdictions, AI is not yet known legally, and it may not receive protection under the law. as it were, in most jurisdictions. So those three things I've pointed out are critical things, why makes the status of the inventor very, very critical when it comes to this discourse. But then, like Mrs. Ifolua mentioned, this is an evolving thing that will keep, there is going to be a lot of discussions around this so that every member state in the various international treaties and conventions will be able to know how to manage this situation. I believe in the course of this discussion, we'll probably be making reference to some other case studies that have received some international attention on protection of certain IP, AI, IP rights and all that. So economic rights, moral rights, accountability, these are the major reasons why there has to be an inventor and not just AI as it were. Thank you.
Okay, thank you so much, Mr. Izochukwu, for that answer. So if I was listening correctly, you said because there's need for accountability, they would have to know who the particular owner of the creation is. And then because AI is not really known or recognized in some jurisdictions, it's important that a natural person is known to be the inventor. So that brings me to my next question. And I'll be using the case study of the Davos case. That is the device for autonomous bootstrapping of unified science that was created by Dr. Taylor. So that invention was in so many jurisdictions, the patent application made on that invention was denied because they said an artificial intelligence cannot create, even if the owner, or rather the person who initially created the artificial intelligence, claimed that, okay, can ownership be in my name since I created this invention that created the other ideas and the rest of that. So I want to ask, since this subject matter of patent laws can be read more broadly to recognize an AI system as an inventor or co-inventor in conversations that are significantly becoming mainstreamed. For example, the Australian federal courts that set the precedence in the Debos case that I just mentioned, saying that an AI cannot be an inventor and that Davos failed to meet the statutory requirements of being a natural person. All right, so we have several jurisdictions with several laws, and given that the global patent ecosystem seems to be unequivocal in the stance not to grant patent rights to machine AIs or AI systems, do you foresee a time in the near future where rates or complexity of technological advancements will force a complete change in IP jurisprudence? Mr. David Brown, this question is for you.
Okay. So I think with every new technology, I don't know if you can hear me. Can you hear me? Yeah.
Yes. If you can speak up a little bit.
Okay. Yeah. I said with every new technology, we always, I won't say we're scared. There's no basis. There's no basis for it, right? So we don't know. Okay, hey, how is this thing going to? It's going to be a slippery slope to something crazy, right? But at the end of the day, if you quoted Australia, the Australian judges said yes to AI first, and I think it got reversed if you check the case, right? So they actually, one judge, probably, I don't know if it's a Gen Z judge, sorry for Gen Zs out there, I mean, you guys are, we're still trying to catch up, right? They're like, yeah, of course, AI can own the patent, right? And then, of course, it was reversed. So you could see that even within the legal profession, right, there's some, different opinions. So it's new. My question is, hey, was it really generated by AI? At the end of the day, you need to program these things, right? You need to feed it with data. How they get the data is another story, right? There's also some patent rights there. There's some books. I asked AI, I tricked AI once. I asked it, hey, have you read this book? Oh, yeah, I've read the book. Okay, give me chapter 2. Give me that chapter. I said, but how do you have the rights to read this book? I mean, this book was patented, right? I mean, did you buy the book? How did you get the book? And isn't that illegal? And of course, it started hallucinating and giving me stories why it was legal for it to have the book and stuff like that. So there are murky areas that are going to we're going to go through them, right? And just like every new technology, there's going to be lots of creativity that comes out of it. And in this case, the Davos itself, was it the one that created it, or was it the prompts, or was it all the prompts and the programming that made it be creative? And even that creativity, where does it come from? If we sue, can we sue Davos? I mean, can it pay fines, right? At the end of the day, the owner is the person that actually invented that thing that is, in quotes, inventing new content or inventing new ideas, right? I think an interesting question would be, let's assume Thala, the inventor, doesn't have an estate and unfortunately passes away, and Davos continues to produce new content. Because right now, I think he should be, Stephen is his name, I think, Davos, he should be the actual owner of the patent, Stephen Thala, right? But if he passes away and Davos continues to produce content and there's no estate for Mr. Stephen Thala, what happens then? I mean, so there's always going to be new areas to look at and decisions to be made. And I think the courts are going to have an interesting time. There are quite a lot of cases out there right now that I think we will be looking at closely to determine what happens to patents, what happens to people's rights, right? So I think who was the Getty Images that has a big class action lawsuit out there saying that all their contents, their pictures and everything, which is all intellectual property, was used to train all the different AIs, the AI products. You have, I think there's another case of Do Not Pay, right? A class action lawsuit where it says don't pay a lawyer, have a free lawyer and legal advice for free. And that's also causing problems because someone is suing them for bad advice. So, and you have a license as a lawyer in quotes. So there's no yes or no, but I still think that a human really is at the back end of whatever AI is produced, and whatever good or bad, some human has to take responsibility. So that's the current position, and that's what I think would stand. Maybe as AI goes to Mars, probably when they land in Mars, it's only AI that's landed in Mars, they could probably start taking rights, right? Because it's going to be populated by bots first before humans. That's Mars. But just thinking far out. So yeah, I think the Australian case and South Africa, I think the case, the UK as well, stating that only humans for now until the laws change. I think that's what's going to stand.
Precious. If I may chip in addition to what David had already said, you see, in the case of South Africa, where that registration was accepted, a lot of persons have argued, and rightly so, that why it was actually passed the South African system majorly for two reasons. One, in the South African laws, they do not have a definition for who an inventor is. And secondly, it is said that South Africa does not, as it is currently, they do not have a substantive patent examination system that will be able to subject that invention to scrutiny to determine its ingenuity and all of those other things. So that was exactly why it basically passed through that system. And I'm sure that if it is actually tested in the courts, in South African courts, possibly before it gets to their Supreme Court, it may also be rejected, just as it happened in Australia. And then in UK also, there was Teller and his team had to withdraw the application because they already saw that it didn't meet the statutory requirements and all that. So it wasn't like an outright rejection, but they saw that it didn't meet the requirements. So this still boils down to the earlier point that all of this, the idea of IP rights in the first place is an issue, is the invention of statutes, and it's only statutes that will also determine how this thing works. I needed to chip that in as well. Thank you.
All right, so thank you very much, Mr. David. Thank you, Mr. Izu, for your contribution. Okay, so I'll be moving on to my next question for Dr. Ifeoluwa. Okay, so my question is, how is the creative industry and the creative ecosystem as a whole, that is including film, gaming, music, and all of that, how are they responding to the proliferation of AI-generated content? And what measures, in your opinion, can be adopted to preserve the creative genius of natural persons? Ms. Ifeoluwa, please, are you there?
Hello, can you hear me?
Okay, yes, I can hear you.
I think I have a problem in my net. Can you hear me now?
Yes, I can hear you, sir. Okay, I think Hello, Mr. David. Were you speaking? Are you trying to take the question?
I seem to have had a connection issue, so I didn't get the question.
Okay, so I'll take the question again, and I think you can help us answer. I think we lost Mrs. Ifeoluwa. All right, so I asked, how is the creative industry and the creative ecosystem as a whole, that is including film, gaming, music, art, and the rest of that, how are they responding to the proliferation of AI generated content, and what measures can be adopted to preserve the creative genius of natural persons?
Yeah, this is
Hello,
a
Precious. Can
very.
you hear me?
Oh, okay, you're back. All right, good. Maybe you can go ahead.
All right, thank you. Precious, can you hear me?
Yes, I can.
All
All right,
right,
thank
okay.
you.
So sorry, I had problem with my network. All right, just to answer that question briefly, I will still give the floor to Mr. David Brown to add his own input as well. So I think that first of all, the initial reaction has been one of fear, like Mr. Brown mentioned. Initially there were strike actions in the US by various creatives servicing Nollywood, because they don't want AI to take over the job of human creators. But I think that over time, everybody is now embracing AI, and we are recognizing that the technology is here to stay. We cannot stop it. We can only regulate it to ensure some kind of ethical use, right? And good use, basically. So I think that generally the creative industry is embracing it, but on the condition, right, that it still preserves the jobs and creativity and the intellectual property rights of the human creators. So generally, you have these discussions going on regulation of AI, ethical use of AI. Various industries and sectors, including in the creative industry, they are bringing out regulations and policies on the proper use of AI. Intellectual property policymakers and lawmakers are also discussing how to adapt AI to ensure that human creativity is very much preserved, recognition as well as monetary compensation goes, to the human creators. So I would say that we are still in a phase where we are all trying to find our feet, really. But I think the initial shock and fear of AI is reducing, and now we are more focusing on how to use AI for good. And there is also the part of disclosures. So as much as we are not all against using AI at all, you should disclose. You should disclose probably what you use AI to do, what percentage of this game or movie or music, just disclose that this was AI assisted. You've used AI in coming up with this thing. So there's transparency aspect. And some of our social media posts are already saying that, especially on Meta, where to detect, or you can indicate that this was something you use AI in making this post or doing this video or image or music. So there's the aspect of transparency, there's the aspect of having an ethical use, and there's also the aspect, of just trying to balance now. To balance and make sure that AI is not used to the detriment of frustrating or taking away the rights of copyright or intellectual property rights owners. I hope that helps.
Okay, Miss Emily, would you like to add anything to that?
I don't have anything to add to that one, but I can go
Over
a
to
little
you,
bit
Precious.
more. Yeah, go a little bit more back into the class action lawsuit. I know that some authors have against AI. I know that was something else that we wanted to mention.
Sorry, Precious.
Thank you, Emily.
Okay,
just
okay.
okay. In addition to what Folua had said, there is a current case in US where one Michael Smith has been indicted with fraudulently, using artificial intelligence to stream multiples of music. He produced the music with AI, thousands, hundreds of thousands of music. He continued to stream them and end up to over $10 million. Currently, he's been indicted with the AI company that enabled him to do this. So this speaks to the fact that, ethical rights and economic rights is a right that he's not meant to have, economic right, but he's benefiting from that. So this basically underscores the influence of AI over musical productions and creative acts.
Okay. Okay, and I think Mr. David Brown was trying to share something as well.
Yeah, so I think are the people going to lose, I think the main thing is that people going to lose their jobs, right? I mean, all the people doing movies and stuff. I don't know. Sometimes I think the Netflix movies have an AI algorithm, right? That they're just using to what's successful, what do people like, and the script is being written by AI. I know the same kind of stuff. Now, there is creativity when you write AI, when you use AI. But again, you have to remember there is someone doing the prompting. There's someone prompting the AI to get that excellent output. So it's still a human behind it. And guess who is best at prompting for a movie or best at prompting for music is probably a musician, right? So and you have to understand that musicians also get inspiration from other musicians. So there's always been IP issues around musicians as well. As in, have you picked from who did you pick from? Blah blah blah. But at the end of the day, do you remember Napster? Let me even say, do you remember the Napster times when there was the legal issue around sharing files, sharing music files? So if I buy music and I share it with my brother, is that illegal, right? Am I stealing intellectual property? So Napster, that was one. Of course, Napster wasn't successful. Apple brought out the Apple Store, and the rest is history, right? Everybody sells music in very different ways. Music industry before, we used to make money from records, selling CDs, and then now it's more going on tour. So going on tour, AI wouldn't go on tour. I mean, some people wouldn't go watch AI on tour, right? They would really watch humans. Who knows? Maybe they would watch AI, maybe some robots, right? So the world is changing fast, right? And we just, unfortunately, it's not something that the US says, do you know what? We're not allowing AI to write music. Guess what? Canada will allow AI to write music, and the music will still go into the US. So we do need to think critically. And labeling, I think, is going to be a very important thing. This is AI generated, this is AI assisted, or this is human. And you decide, do you want to drive a Rolls Royce that's handmade, or do you want to drive a Passat or something? Do you get? At the end of the day, you need to make a choice. What do you want to buy? You want to buy the human variety, or you want to buy the AI variety? It's your choice, right? And I'm sure the human variety is going to be much more expensive in the future. You want to get a human to train you, it's going to be very expensive, but we need to label these things, right? So I think that's what's going to be very important in the future.
Okay. So with that, we understand that what is important is the labeling, the disclosure, so that the outside or the people that are taking in this information will know that this was AI generated and this was human generated. And even down to the point of protecting or registering the intellectual property, it's important to disclose that there was some AI assistance in generating this particular creative work or whatever it is. Okay, so with that, it means that the humans might not necessarily lose their creativity since they are still the ones behind the AI giving the prompts and all of that. Okay, so I'll move on to my next question. My next question is for Miss Emily. All right, so now considering the fact that most of these AI that we're talking about are produced out of already existing data or proprietary works, they are fed with already existing data, which may not necessarily be open source. As a matter of fact, some of this information could be already protected by the original owner, and then these AI have the accessibility to it, of which could be the fault of the developer or whatsoever. Now, infringement becomes a very huge concern. In recent times, we've had prominent authors such as George R.R. Martin, Mr. John, who have filed lawsuits against OpenAI, claiming that they have infringed on their copyrighted works and that the AI models provided detailed word for word excerpts of their copyrighted works. So now this would raise the question of at what point will AI models or their underlying algorithms be said to have infringed original literary creative works, and what do authors and creators do under the existing laws, given that the laws have not been modified? So with the current laws we have now, what should creators do?
Yeah, thank you for that question, Precious. And the short answer of the first part of the answer or question, sorry, that you said, what at what point does it cross from from not infringing to infringing, right? That is still being determined. Unfortunately, we're still in the early stages of AI, and and we don't fully know. The court case that you mentioned in the United States is actually a class action lawsuit of many different authors against OpenAI, which includes ChatGPT and among others. And basically, the essence of the lawsuit is that ChatGPT openly admitted up until the lawsuit was filed, actually, that it had read all of the books of all the authors that are alleging in the complaint, and when prompted, would even regurgitate an entire chapter or a highly detailed summary of a chapter of those books. Now, once the lawsuit was filed, then ChatGPT, when prompted, would not regurgitate those, but obviously it was just trained to do that by the programmer, right, in light of the lawsuit. But it still doesn't solve the question of ChatGPT or all these authors' works were used to train ChatGPT, right, and it did so without paying any licenses to the authors of the work, right? And so that is something that the authors, basically, that outside of AI, no one else could use copywritten works and basically develop a whole business model around it without paying a license, right? So that was pretty essential to the complaint, that the AI is not even paying licenses to use these works, and it's benefiting financially from training the AI model on all of these works. And then there's all these derivative types of companies that are popping up where they're providing prompts. I know someone else mentioned that someone has to be on the other end, right, to prompt the AI in order to give like an appropriate response. However, there's all these companies that are now popping up to sell prompts that allows users to enter the world of an author's books and create derivative stories within that world. And as you know, well, especially in the US, since I'm a California licensed attorney, in the US, we also protect derivative works, right? So not just the original work, but anything that's based on that original work of authorship. So, for example, there's this company called Social Draft that offers very long, detailed prompts so that users can engage in conversations with popular fiction authors, like you mentioned, George R.R. Martin, Dan Brown, among others, and also to even write books. In the lawsuit against OpenAI, against all these authors, they actually engaged in a conversation with ChatGPT to write prequels and sequels and other aspects of George R.R. Martin's book that aren't actually written yet. So it asked ChatGPT to write those unwritten books, and what came back actually sounded like it could very much be an original work of George R.R. Martin, right? So that's part of how it's just so complex, because we don't really know at what point it begins and ends, and that's still being litigated because AI is using other people's original works and being trained on those people's original works, and then somewhat giving it its own creative mind per se, and then almost circumventing that, like almost becoming that person like George R.R. Martin and being able to write a book like him. And the complaint also discusses how there are already instances of authors who have gotten their jobs taken away from them because to write short articles or whatnot, because their clients would rather use ChatGPT, which was trained based on authors' creative works, right? So it's kind of taking the benefit of what authors have done without giving them credit. To answer the second part of your question, what can we do in order to prevent our works from being infringed upon? The best course of action is always to make sure that you have a copyright, right, for all of your works. Like, even though we don't know the legal repercussions of how this is all going to be played out in court, because the court case that I mentioned is still ongoing, you can still file a copyright, right? You can still send cease and desist letters against those who are infringing. You can still act as if you are enforcing your rights, because those, at least in the United States, those are very important parts of enforce or having IP right, is that you enforce it as well. So I think just taking all the traditional steps of protecting your work is extremely important, and then just trying to stay aware of where all of this is going, and how the laws are approaching, and then if you're, especially if you're a creator, right, make sure your works are protected. And then if you are someone on the flip side using AI, I would say, be very careful, right? When you're using this, whenever you're using AI platforms, realize that these platforms are trained on copywritten works, and we don't really know how that's all going to play out. So make sure that if you do use AI, I would recommend using it as a tool, maybe as a starting point, and then you put your own creative element and modify it substantially so that it becomes your own, right? I think that would be especially if you want to later claim copyright for your own original work in that matter.
Okay. Thank you so much, Miss Emily. So, we are being warned to be careful if we use AI to generate content and to modify, to give it a more natural touch if for any reason we intend to claim ownership to that right. All right, so coming to the point of, you said what creators and authors should do is have a copyright. So what happens in the situation where there is a copyright? And this question, I'm throwing it to you, Mr. Izuchukwu. There is a copyright, or the property has been protected as it should be, and then there is an infringement. So who is accountable for the infringement on this that has been done by the AI? Ms. Emily had said that the owners should have a copyright, and then so that they can at least go to court. We do not know how the case would end. But who do you take to court? Who should be accountable? How should liability be allocated, considering such factors as intent, knowledge, contractual agreements, industry standards, and the evolving autonomy of AI systems, amidst the need for clarity on roles and responsibility, transparency, and the applicable laws and regulations? Who should be held accountable, Mr. Izu? So you're muted.
All right, sorry about that. In these regards, there are three major stakeholders when you talk about liability. You have the developer, that's the creator of the AI. You have the user, the end user, who will probably use the AI to create content. And then you have someone we'll call the distributor, who publishes the content itself, the likes of Facebook, Instagram, Twitter, and all of that. So first off, all of them will be liable at one point or the other. So liability depends, it depends on the circumstance. It depends, it's a case-by-case issue, as it were. So in the case of the AI creator, the developer, it is expected. You've made mention of intent, knowledge, industrial standards, and all of that. So in the case of the AI creator, it will be expected that they will be liable, the creator will be liable if they do not adhere to, specific industrial standards in creating that AI tool itself. For example, if you've, just as we've listened to other speakers, starting with Emily, when she made mention of, in trying to define AI, as it were, AI basically takes, derive everything it does from existing data across various platforms and all that. So if the creator of the AI didn't get the appropriate license in developing this particular artificial intelligence, he didn't observe that particular, he didn't get the requisite license and all that, it is expected that it will be liable if there is an infringement at the end of the day. On the other hand, for the user, if the user also knows or ought to know that a particular content that is being created with the use of an AI, whether that AI, whether the creators, the underlying data were licensed or not, if at the end of the day it makes a content out of this tool, the AI, and that content eventually infringes on the rights of an existing IP, a protected right, then it will be safe to say that the user himself or herself will also be liable to some extent. Talking about the distributor can also take some level of liability if what is being published by them on their various platforms are continuously breaching certain certain IP rights. So liability can also be attributed to them, although for distributors mainly, and a lot of them actually take leverage on this particular defensive protection. That is they take this defensive protection that is available to them, the safe harbor, protection, whereby upon notification, they can easily remove whatever is the offending publication content that is on their platform. At that point, liability shifts away from them. It comes to the user or the AI developer. So ultimately, liability is a kind of shared. In some cases, it might be shared across the three of them. In some cases, it will possibly lie on one person, depending on the specific case in question. If, for example, I use ChatGPT to develop a textbook or a publication that infringes on an existing publication, an existing documentary that is already protected, the developers of the AI, the creators may not be liable. Myself would be, because I ought to know that the context that I'm already creating and feeding AI with certain information and controlling it to some extent. The creators, the developers, they may not know the level of control I have over their tools. And so they can also get exonerated. So this is basically the level of control over the AI, the intents and knowledge available to each party will ultimately determine the level of liability each party is going to bear. So in contractual relationship anyway, I think you made mention of issues of contractual relationship. Once this has also been documented, each party can take protection on the contractual arrangements that already exist. That's why you have terms of use, privacy, terms of privacy and terms of use for various on various platforms and all that. So once you done through these things and you sign off, you don't know that they have already exonerated. They say, whatever any user does. So this particularly, so what I'm saying is that on the bulk of liability will lie on the users. That is why every user of of AI machines and AI tools will have to read both the terms of use by the creator and the terms of use by the distributor, so that you know the level of protection you may have to have for yourself. Thank you so much, Precious.
Okay, thank you so much, Mr. Izu. So the terms of use, I am very certain that almost, would I say 90% of people hardly take the time to read the terms of use of any application or whatever it is. But going by what you've said, the developer and distributors at this point can actually disclaim liability, and then it leaves you, the user, to act right, or if you infringe, then you would be the one to be held liable for any infringing content that you create using that AI. Okay, I don't know if any other speaker has something to add to that, or we would be moving on to the next question.
Yeah, so I just wanted to add a little bit there. I think especially to what Emily mentioned. I don't know if you can hear me.
Yes, please.
Yeah, because she mentioned about the Authors Guild against OpenAI, right? Authors Guild class action lawsuit. And one thing you have to understand, and I think when it comes to innovation, right, I'm sure all of you know that the US, nearly every major innovation is coming out of the US, right? For Europe, just seems to be like a black hole. There doesn't seem to be much innovation coming out of Europe, because Europe has a different approach. Europe kind of takes that safety, that ethics, that we'll call it ethics really, more seriously than the US. But unfortunately, that impinges on innovation. Simple thing is, the US take OpenAI. They lawyer up from the beginning. Why do they lawyer up from the beginning? Because they know that, hey, let's break and then solve problems. That's the approach. Let's go all out. Yes, we know we're doing stuff illegally in quotes, but when we finish innovating, and we can correct that with our lawyers. So take even the voice, the AI voice, Scarlett Johansson, right? So Scarlett Johansson, what's his name? Sam Altman called Scarlett Johansson up and said, hey, we would like to use your voice for our upcoming voice AI, so for the voice of OpenAI. And she said no. He called again, asked her, and she said no. But guess what? They released it anyway with her voice. And what does that tell you? That tells you, hey, we have lawyers here that they can sort things out while we move forward with our innovation. We're not going to hold down our innovation to move forward. Now, is that a good idea? Well, I would really love Emily's point view on this, because at the end of the day, yes, they've innovated and they will solve the problems. Meanwhile, Europe will say, okay, fine, let's find another way. Let's not innovate. So it's unethical in a sense, but then it kind of pushes innovation forward faster. And of course, there's lots of class action lawsuits now, right? And we're going to listen and see who wins. Getty Images against the Stability AI lawsuit. There's the group of people that came against Midjourney and Stability AI as well. And then, of course, this Davos case that you've mentioned, the Authors Guild case against OpenAI. There's quite a lot there. At the end of the day, they may clean up their act, right? I think there was one case about a teenager that died recently. That died because he was listening or was going through this AI that was supposedly safe for kids, and he committed suicide, right? Because immediately after chatting. And of course, so there's a lot that would happen, but innovation is pushed forward by almost ignoring legal incidents or precedents or IP issues, and innovate, and then, hey, our lawyers will solve it. So that's the kind of approach I see in the US. Is it correct? Well, we're enjoying the OpenAI right now. We're enjoying the technology, but how we got there is a different thing. And I think typically what happens with laws, right, is when something big happens, that's when we'll come together and try and solve it. Some very tragic thing happens. That's when we'll be kind of jolted to solve it. Can we solve it by just discussing and trying to be ethical and solve the problem before tragedy strikes? Unfortunately, I don't think precedents and history doesn't show that we do that. We kind of wait for tragedy first and then we solve. Highly unfortunate, but that's just something I've seen.
Okay, so we keep hoping that the laws will continue to evolve without any tragedy occurring. We want the policymakers to see these things ahead of time. All right, so I'll be moving on to my next question for you again, Mr. David. Okay, so in light of the European Patent Office updated guidelines for examination of patent applications, which necessitates stronger disclosure requirements for AI-related inventions, how should IP laws strike a balance between accommodating AI-driven innovations, ensuring sufficiency of disclosure, accountability, and addressing practical privacy and proprietary concerns? Sorry, sir, you're muted.
Oh, sorry. I think I'll lead on what I already mentioned about Europe, right? Europe being, should I say, the responsible one. And GDPR came in from Europe. Eventually, that spread around the world, right? But kind of stifling a little bit of innovation. So AI innovation disclosure enhanced, I think the European Patent Office with their enhanced disclosure requirements, right? And yeah, AI-driven innovation. You're asking if between the balance between AI-driven innovation, ensuring sufficient disclosure, right, accountability, and addressing practical privacy and proprietary concerns. That's what Europe does, I think, reasonably well. But there is a balance, and funny enough, I think my last question kind of answered this: that break first and solve later is what America does. Innovation kind of moves faster that way. Europe wants to solve first before we innovate. That actually stifles innovation, unfortunately. If you remember when this clone of this sheep, the Dolly sheep happened. I think that happened somewhere in Scotland, I think, if I can remember right. But then there were some restrictions around embryo research and all this stuff, which is true. I mean, embryo research, but then, of course, other countries kind of took that over and then innovating faster than Europe. Now, I think the world can learn a lot from from the standards that Europe is setting, the privacy and proprietary concerns, disclosing detailed training data algorithm may raise concerns about revealing proprietary information or compromising user privacy. So how would you show what you trained, everything, single detail about how you trained your AI? I mean, that should be your IP too, right? But then you need to show that, okay, someone else can replicate what you did, and to say, okay, that is true creativity. But by doing that, the work that you did, your IP is open for other people to take advantage of without them doing the hard work at the back end. So there's still a fine line. We're all learning, and things will continue to change until we get a balance. So I think we can take what their work is as just another step, and we then would have some more challenges to then solve. But I like the fact that government is now doing stuff. If you remember 5 years ago, there was really nothing. Government wasn't doing anything, but now government is catching up, but I still think there's a long way to go.
Okay. All right. So we're gradually coming to an end. I have my last question, but I would like to encourage our attendees to use the questions and answer option on your screen and ask your questions if you have any. Just type in your questions, and at the end, our speakers would attend to them. Okay, so this is my final question, and I'm throwing it open to all the speakers. I would like to hear everybody's opinion on it. So Mr. David had mentioned that Europe has a different approach, America has a different approach. A country like Nigeria is still trying to approach well. So how do the divergent national approaches to grant IP rights over AI-generated works impact international businesses and global IP protection? Is there going to be a point where these different jurisdictions will come to harmony, or are they going to continue to have different ways of addressing this situation? And then if they do, how would these affect global protection of intellectual property? This question is open. Any of the speakers can answer.
Okay, let me chip in something in regards to that question. In terms of how it's going to affect international businesses, I think it was a follow, or is it Emily that made reference to the fact, intellectual property protection, first of all, it helps to encourage human ingenuity and inventive, to encourage human intellectual processing unity, if I will put it that way, and to also encourage healthy competition. Now, if all and every invention made by AI is allowed to be given protection by national laws or even recognized internationally as it were, without certain level of restriction, one, as to regards to who the inventor is, or as regards to the length of the protection, then it is really going to dampen the spirit of genuine, because to make an invention, it's not a walk in the park. You sit down, you think, you process a whole lot of things, but using machines, AI, there are things you can do in splits of seconds, is really going to, kill that healthy competition that is required. So, and it is going to affect genuine businesses and all that. So that is on one hand. On the other hand, what can be done by various international organizations like WIPO and all of that? I think whatever they will have to do will have to start from the various member states. And interestingly, just yesterday, WIPO concluded a 2-day section on similar discussion we're having. And before that event that concluded yesterday, they've had various sections on AI and IP related matters, starting from way back 2019 and all that. And since then, there has been consistency with regards to member states, developing laws that should be able to provide for this, because we can't shy away from the fact that AI has come to stay with us. So the question is then, what next? So this is where both the member states, through the instrumentality of their laws and regulations, at their various patent offices and copyright commissions will have to put on a thinking cap, think of what to do. And then at the international level, through the various treaties and conventions, a lot of them now have to be updated in line with the current realities. A lot of papers have been submitted by both the regulators, by industry users, by policymakers, and all that. So all of these things will accumulate to where we are going to foresee a possible international convention that will bring everybody one more to the table. But as for giving protection to AI generated works, as against AI assisted works, giving protection to AI generated work, I think it is too premature until there has been a collaboration between member states of the various treaties, carrying along industries, private businesses that are into creation of AI tools, and then have a well-detailed and well-dimensioned approach to this issue. Until that is done, I believe we may still be having this crisis, these divergent opinions, and it will create crisis in issues of enforcement and issues of claims and all that across various national borders. Thank you. So yes, I foresee an international convention on this matter very soon, but it may not be this year. It may not even be next year. Thank you.
So if I may add to that, for me, I think human beings are pretty simple. It's very easy to control what we do. I think I always believe in incentives, right? So economists, I think, really rule the world. Wish I read economics, because everything is about incentives. So is there an incentive to do A? Is there an incentive to do B? They need to get. You mentioned the world WIPO, right? As in they don't have any stick. There's carrots and stick. They don't have any stick. It's not like the International Criminal Court where you could say, okay, you've infringed on this and we're taking you to WIPO to get reprieve, right? To get the case, get them to basically help get me back my rights, right? So it's more. I think there needs to be more teeth. The world IP. What's WIPO? WIPO is the World Intellectual Property Organization, right? It needs to have some teeth. I don't know how it will get some teeth where you can actually sue, regardless of which country. I mean, you could say it's illegal in country A, and then you just go to country B and do the same illegal stuff, right? And they accept it. So there needs to be some more teeth. There needs to be some more consequence for certain actions, and controlled and by probably a more enforcement body of the World Intellectual Property Organization, right? And then there will be an incentive to actually act well. So a lot of the bad actors that we're going to have will basically have an incentive not to, because right now I don't think they do.
Okay. All right. So thank you very much. Thank you so much to our speakers. And now I will be going over to the questions from our audience. Okay, so we have a question from Rose. Rose says, in line with the AI generated innovation, what happens to trade secrets in IP? Because if AI is allowed to use people's works without their knowledge, that means the trade secrets are no longer safe. Or is there a way out for trade secrets? I would like Mrs. Emily to answer this question.
Hi, can you hear me?
Yes, please.
Hi, thank you for that question. So I can only answer this as to U.S. law, but trade secrets in the United States are they are a form of intellectual property, but they're protected differently than copyrights and trademarks. So for copyrights and trademarks and patents in the United States, those are protected by securing a registration with our government, right? So you get a trademark registration or a copyright registration or a patent. And so those are secured by making them public and securing a registration. However, trade secrets are a little different in that you protect them by not letting anyone else know about them, right? So you want to protect them and keep them secret. So I think what you may be asking is, if you're putting potentially some of your trade secrets into AI and then AI is learning based on your input and then being trained based on what you're inputting, I would say, yes, that's a very real concern. So I would never put anything into Chat GPT or any AI platform that you consider to be your trade secret, because Chat GPT is learning based on what you put into it. And if that's something that you want to keep secret, because you do consider it a trade secret, then I would not put that in there. So be very careful what you put into the models, even to help you. You know, whenever I put things into AI models, I strip it of all confidentiality or any type of confidential information or anything that I wouldn't want the AI model to know or learn based off of. You could just put brackets around whatever it is that you don't want it to know, that kind of thing, and to keep it more of a higher level. That's kind of what I do. But in terms of recourse, we don't really know what type of recourse is going to be available to consumers, right? So we've heard from the other speakers that there's a difference between Europe and the US and how we're handling it. And so the US is highly litigating all of these AI cases. And so since it's so new, honestly, it'll probably take decades before we even know and have case law in the United States that's going to provide a recourse for individuals. And until then, the only thing that you can really do is safeguard your trade secrets and make sure that you don't put them into the various platforms.
Okay. That's basically the same position in Nigeria. Trade secrets are not registrable. So if you have something that is confidential to your business, you're advised to keep it out of all AI platforms so that they won't learn it and they won't use it subsequently. All right, so we'll move on to the next question from Lois Moses. Lois Moses asks, in the long run, would we possibly see more creators collaborating and building their own data set libraries to distribute their original and derivative works under a license scheme? Mr. David, I would like you
Yeah,
to answer the question.
yeah, I think that's a great idea and a great opportunity, right? For AI to legally go through the entire body of work and then combine it. So, but I think for that to work, we need a way to actually define derivative work, as in how can I get some content from, let's say, OpenAI or something, and I'll be able to identify that this is the derivative work of X or Y. What's that threshold? Why I'm asking is, if we can identify that threshold, then we know that, okay, for me to really to use this content legally, I should go to this body of artists, right, that have created this company that has all their work in there, and you can go and query their AI and get the content that is legal. Because if you use anywhere else that has this similar derivative work, it's illegal. And I think that will make them thrive if they can kind of build that up. And so I think that definition of clear definition of what is derivative, and AI can help us even do that as well. So AI can kind of scan the internet and say, okay, what is derivative work? What is this derivative of? See Morgan Freeman's voice, for example. Can he patent his voice, and anyone else that uses Morgan Freeman's voice is a derivative work, right? So I think that would make it successful, but I think it's a great idea. Get as many artists as possible to actually legally put their work through their own AI, train it, and then sell it, and then have people actually use it with their stamp, with their digital stamp. Maybe there will be some blockchain stamp, right, that can say, okay, this work came from the right source that owns the intellectual property. So yeah, I think it's a great idea. If we could define derivative work and use another AI to identify illegal derivations, I think that will be successful.
Okay, all right. Okay, so the next question is from Chiwendu Okeke. Chiwendu asks, in a scenario where an AI software, e.g., an image generator, is used by a person to generate an image or a video, is authorship attributed to the person who generated the image or the video, or to the creator or inventor of the software? Miss Ifeoluwa, could you please help us answer the question? Okay, I All right. Okay, so I think she is not here. Mr. Izuchukwu, can you please help us answer the last question from Chiwendu?
Okay, sure. All right, Chiwendo, thanks for that question. So I don't know at what point you joined, but it has been partially addressed your question. So if an AI tool has been used to generate an image, and again, of course, it depends on which jurisdiction you are. If you are in South Africa at the moment, for example, it means that depending on who you provide as the inventor, it could be the AI, it could even be the AI itself. It could be, so whoever that presents, that brings that particular work for protection takes the credit. It doesn't matter who basically did it. Once it hasn't been protected, whoever that brings that for protection gets the credit. But if we're to speak in the realms of assumption, what determines who takes the credits, again, going historically and looking at the laws, will depend on the level of control. In this case, the level of input, the human input that has been made into that. If it is an autonomous creation, that means there is no human input. Currently in Nigeria, for example, or in Australia, for example, or in the US, for example, you may not get protection for that because it will have to go through certain system to determine the level of input that has been made by a human factor. But if you are somewhere in South Africa, for example, you can have it protected. It can be protected in the name of whoever, since they don't have a viable system to detect all of that. So, but generally, if there is enough human input by you, the content creator, then you can take ownership of that creation. But if there is none, then it can as well be given to the AI creator if the underlying data that they used in training that AI, because AI learns and then provides solution based on existing data. So if the data the creator has used to train the AI is properly licensed, then they can also get credit for that. So it all depends on who has more control or who has provided more data for the AI. And of course, we've actually been speaking generally. Each case will also depend on what is being done. For example, you're talking of issue of trademark, or you're talking of issue of copyright, or you're talking about issue of patents. Each of these will also determine your inputs at different levels for each of these will determine the kind of credit that will be given to whoever that is presenting that application for protection. I don't know if that has been able to, if I've been able to answer your question to some extent. I hope I did. Thank you, Precious.
Okay, thank you. So just to add to that, most jurisdictions are still of the opinion, like Mr. Izu has said, that there must be sufficient human input to what you are producing or to the image or the video or whatever it is. So there is this renowned case of Zaria of the Dawn, and the court accepted safeguarding the text and arrangement of images, but it refused protecting the image itself because there was no sufficient proof that there was enough human input in the creation of the image itself. So even if the person had prompted the AI on the text and the arrangement of the text, it did not create the picture. And as such, the court refused protection of that image. So what matters is that there is sufficient input of the human, and at least they are able to prove that. Okay, so I'll be moving on to my next question, and we are already 2 minutes behind our scheduled time. So I'll just ask this question. That would be the last question, and we'll move on. So I'll be throwing this question to Mr. David. Please, if you can answer in 2 minutes. Mr. Bulorin said that he has created a model, an AI model, out of another one which he significantly updated. He got licensed and modified, and now it's time for him to introduce it to the world. and he wants to know what he can do to make sure that other people do not duplicate the product.
Okay, so I mean, this your classic case of you've built something, you bring it out there, and you're afraid that someone may steal it. But you have the code. I mean, the code and everything is at your back end. You own that code. So let me use something in finance to kind of try and answer this. So there's this mosaic theory in finance, right? That refers to the process of gathering pieces, piecing together non-material, non-public, right? Non-material, non-public, and then public information to create a comprehensive picture that aids in decision making. So let me use that to say, okay, you've released your model. It's working pretty nicely. Someone is prompting it and prompting it and prompting it in a way to try and get insights into how you built it. Your code is still your code. You still have it there, but someone has worked enough with your public information, which you've made public to everyone, to try and build something similar. I do not think they haven't stolen your code directly, because if they steal your code, for sure, I mean, you can sue. But they've creatively created something that does something similar to what you've done by building theirs. I don't think there's anything illegal about that. How do you protect yourself? I think the best way to protect yourself is to grow. Hopefully that will blow up, your tool will blow up very fast, and you can take a big chunk of the market. But it can't stop someone else building something similar. Forget AI now. Even you have a product. Samsung used to build Apple phones, right? Until Apple decided, you know what, we're not giving Samsung the contract, because Samsung is now copying those stuff and building phones that are similar to Apple. At the end of the day, you've taken this public information and also non-material, non-public information and come up with something similar to the other product. Yes, they can go to court. They probably would settle out of court. But at the end of the day, I think you protect your code. That's the most important. Really, really protect your code. And you can't stop someone from being creative and creating something that probably works like yours. I'm not a lawyer, but I don't think you can protect from that. But someone stealing your code directly, for sure. But how would you, if quite a lot of people are stealing your code, how do you protect yourself from 100 people stealing your code at the same time? Is there a class action lawsuit against all of them, or what? I mean, at the end of the day, protect your code, but that creativity will still come in where people can piece together stuff that may be similar to yours. Yeah. So unfortunately, I don't have good news there. I hope someone in the panel has some good news for you. Yeah.
Okay. All right. Thank you. So would any other of our speakers like to add anything to that?
Okay. Yes. What I will have to add is this, Bolurin, what you may have to do, in addition to what Ms. David had already mentioned, you may have to meet with a lawyer who is going to, an IP lawyer, who is going to guide you properly based on where you are operating from. The process of protecting, protection of rights on any particular thing is not automatic. For copyrights and patents, you have to make certain claim. You have to show some, distinctiveness in what you're trying to protect. Is there an element of distinction in it different from what is currently existing? And even if where there is, resemblance to what is existing, you have to show that you have gotten appropriate rights in order to further protect whatever it is you want to protect. So by the time you present your claims and the way whatever you have produced, you've developed the way it works and all that, once you meet all the criteria within the jurisdiction, within where you are operating, then you can put in an application for filing. And once it is protected, you can enforce your right over that within the boundaries of the protection. And of course, if you also want to secure a kind of global protection, you also have to look at the countries where there is a reciprocal treaty between your resident country and those other countries where you want to have them protected. So we may not give you a holistic answer on this matter here. But if you meet your solicitor on this matter, they will be able to guide you properly on how much protection you can get over your work.
Okay, thank you so much, Mr. Izo. I would also like to add that for your software, you can definitely copyright your software and then it becomes yours. Although copyright is granted at the point of creation of your IP. However, it's very important to register it so that you can claim ownership where the need arises. So you can just proceed to register your invention, to copyright your invention. And you can always, like Mr. Izu said, meet a lawyer for more information and guidance. Okay, so thank you very much, our speakers. And with that, we've come to the end of the questions and answer session. And I would like to invite Mrs. Mobola, our partner and head of the Africa Trade Practice Group in Deal HQ Partners, to give the closing remark. And please,
on behalf of Deal HQ Partners, I would like to thank our speakers for their valuable insights and contributions today. We've really learned a lot concerning AI in respect of our creative works and all. And to our participants, thank you for your questions. Thank you for your engagement. And BHP Partners, we are truly grateful for the opportunity to deepen discussions concerning IP rights to generated creative output. And as we conclude, I would also like to encourage us to apply the insights shared today in trying to in our creations and in developing our products and services. Thank you all once again for being part of this event, and we hope you will join us for future sessions. Thank you.
Deal HQ Partners on Instagram, also Twitter and Facebook. Deal HQ Partners.
Thank you for listening. This podcast is brought to you by Deal HQ Partners. To find out more about our services, visit www.dealhqpartners.com. See you on the next episode.